right, next on the morning show, we have a quick update for you on a particularly important case. The Supreme Court is set to hear the suspended BJP spokesperson Nupur Sharma's plea today. Remember, Nupur Sharma is the BJP spokesperson who'd made comments considered offensive to Prophet Mohammed on a TV show debate. Sharma moved the Supreme Court, challenging the previous observation made by the Apex Court. She also appealed to the court to club all the FIRs against her together. Interestingly, the matter today is going to be heard by the very same bench comprising of Justice Suryakant and Justice Pardiwala, who heard the case already on the 1st of July. During the previous hearing, the bench had dismissed Nupur Sharma's plea. They'd held her responsible for communal tensions across the entire country. Very quickly, we want to bring you a brief overview of what's going to take place today.
From violent protests across the country to the brutal beheading of a tailor in Udaipur. The series of events triggered by former BJP spokesperson Nupur Sharma's derogatory remark on Prophet Mohammed left the Supreme Court fuming. On the 1st of July, Nupur Sharma approached the top court citing threats and sought to transfer to Delhi the multiple FIRs filed against her. But the Supreme Court denied the request and instead blamed her for igniting tension. The court said Nupur Sharma's petition smacks of arrogance and that being a party spokesperson doesn't give her the license to incite. The SC also accused Nupur Sharma of being single-handedly responsible for the unrest in India and demanded that she apologize to the nation. The court also said that her comments were responsible for Kanhaiya Lal's murder in Udaipur. Following these scathing observations, several petitions have been filed in SC demanding expunging of the bench's remarks. Then a group of 117 concerned citizens, including retired judges, bureaucrats and armed forces officers, issued an open statement condemning the Supreme Court for surpassing the Lakshman Rekha. The letter said that the observations were not in sync with judicial ethos and are too serious to be overlooked, that Nupur Sharma has been pronounced guilty even before a trial, and that such an approach impacts the honour of the Supreme Court. So are the top court's observations on Nupur Sharma warranted or are they excessive?
The principle that if for multiple FIRs for the same offence, then they can be clubbed. That was a principle that was upheld by no less than the Supreme Court itself. Without going into the comments of what the Supreme Court said and what Nupur said in the first place, is this in principle a maintainable plea?
But the point is, the larger point is that whether or not the test of sameness under which Nupur Sharma is making a plea to the Supreme Court, whether that prevails or not, that is something which remains to be seen, because it is obviously the same offence, same so-called offence of the same debate, the same comment under which multiple FIRs have been filed across the country. So the test of sameness is satisfied. Now the test of consequence, which is the other test, that whether secondary offences are part of the first offences. So there is only the question of the first offence itself, which is that, obviously she, invoked communal disharmony and all of those things. So I don't think that there is a problem there. So I think on that ground and those ground alone itself, the Supreme Court and its magnanimity and wisdom should reconsider her plea. And it can maintain the comments it wants to and maybe dilute that a little bit, but at the same time club the affairs, which is what is most important. It may not give her the interim relief of protection from arrest.
Okay.
Because that is something which the Supreme Court may say that, sorry, we don't want to interfere with the investigation process. But the key, Zaka, here is that the test of predictability and fairness is what is required or what should be made known to the petitioners and to the applicants as well.
Adil Singh Boparai, this is what the court said. Oral observations, not part of the full order, by the way. She has a threat, or has she become a security threat? The way she ignited emotions across the country, this lady is single-handedly responsible for what is happening in the country. The question that's being asked is, if these are oral observations, not part of the final order, two things. Number one, does this not colour the perception of any other judge who may be hearing any of these matters? After all, no judge would want to be seen as, opposing the Supreme Court and the Supreme Court's observations in letter and spirit. And more importantly, was the court itself trying to play to the galleries? Because if they meant what they said, they should have put it in the order, not just made oral observations.
Well, Zaka, with utmost humility, I'm a mere mortal, so therefore I will not go down the path of advising what the Supreme Court should do or not do. I think our judges, our honorable judiciary, is well versed with what the law is, and I'm sure that they'll take a decision as per the Constitution.
Yes, exactly. I mean, I don't see even a single argument against that rationale. Like, we know how slow the Indian judiciary system in India is, and it makes absolutely no sense to, take a 1-1 FIR. So obviously, those 9 should be, combined and be taken together for the same offense. And if there is a minor difference in wording or something, I don't think it's such a big deal to, club it together.